Guys, just take a look at this. Pro-XRP lawyer reveals XPRL SEC lawsuit setbacks, boosting rivals' chances. After being eclipsed by Ton blockchain, XRPL has made a significant comeback in the cryptocurrency world. The spread of meme currencies and the appearance of new apps have breathed new life into the ecosystem, causing it to revitalize. Furthermore, the Ton Foundation's strategic initiatives and strategic awards have been crucial in promoting ecosystem growth and innovation. A more accurate way of looking at XRP Ledger would be as an interdependent ecosystem with many different uses and possibilities, as these new developments demonstrate. The continuing SEC litigation has far-reaching consequences for XRPL and its stakeholders, as Pro-XRP lawyer Bill Morgan explains. Ripple has kept a low profile over XRPL for the past 4 years due to the protracted legal struggle, which shows that the project is uncertain from a regulatory standpoint. As a result, rival blockchain systems have taken advantage of this lack of clarity to their advantage. Investor sentiment, market dynamics, and the price trajectory of XRP are all affected by the ongoing anticipation of the lawsuit's result. While everyone is talking about the Ripple versus SEC litigation, traders have been paying attention to what's happening with the XRP market. There's been a noticeable diversion from legal processes due to the increased emphasis on whale trades. Also reflecting current market volatility and cautious investor attitude is the 3.70 ROP in XRP futures open interest to $505.45 million. Even if XRP's price went up to $0.5 and there was a significant $1.93 billion trading volume in the last 24 hours, the coin is still not doing very well. The cryptocurrency has been struggling in the face of recent price oscillations, as seen by its substantial losses over the past 30 days, 16 in the previous week, 18 ticking. This highlights the prevalent market instability. Optimism over a Ripple launch is sparked by U.S. stablecoin law. A term that could describe the Loomis-Gillibrand Funding Stablecoins Act as a stablecoin. On Wednesday, the spotlight was mostly on Kirsten Gillibrand and Senator Cynthia Lummis. Legislation titled the Payment in Stablecoin Act was introduced by senators. At the same time as it tackles the problem of money laundering and illicit funding, the legislation seeks to protect consumers and promote innovation. Markets is utilized by market traders. It is a tremendous privilege for me to have the opportunity to present the Payment Stablecoin Act alongside Senator Cynthia Lummis, Senator Kirsten Gillibrand said in her announcement of the bill's debut. A regulatory framework for stablecoins must be passed in order to safeguard consumers, encourage responsible innovation, and combat illicit financing and money laundering. The Act's key provisions were also outlined in a press statement by Senator Gillibrand. To maintain one-to-one reserves, e-stablecoin issuance should be mandated, and algorithmic stablecoins without backing should be banned. This will safeguard consumers by thwarting any unlawful or unauthorized usage of stablecoins by users and insurers. Stablecoin issuers should be subject to federal and state regulatory frameworks that aim to preserve the dual banking paradigm. The press release adequately addressed American concerns on the value of the US dollar. The adoption of payment stablecoin laws is critical to bolstering the dollar status as a medium of digital exchange. Establishing coding standards for compatible stablecoins issued by the US will be a countermeasure against foreign nations' aspirations to develop alternative settlement systems, while also enshrining American ideals and the dollar as the base currency for the $4 trillion. In light of the recent events, Stuart Alderati, Chief Legal Officer of Ripple, issued the following statement. The stablecoin bill that Senator Cynthia Lummis and Kirsten Gillibrand have drafted is another step forward for crypto legislation. While much remains to be accomplished, it is heartening to observe that a number of lawmakers are already showing their support for crypto legislation. It is absolutely unacceptable for politics to influence innovation in any way. Given that the SEC is litigating an increasing number of cryptocurrency companies, this bill couldn't have come at a more critical moment. Ripple and the Payment Stablecoins Act are two such instances. In April, Ripple revealed its intention to create its own stablecoin. The stablecoin will have certain qualities such as being pegged to the dollar and supported entirely by our deposits, short-term government securities, and other cash equivalent cities. The advancement of the Lummis-Gillibrand Payment Stablecoin Act in the domain of digital assets may pave the way for the introduction of a Ripple stablecoin. Gillibrand, Senator Lummis, and themselves are experts in the field. The Senators Lummis and Gillibrand introduced the Sustainable Financial Innovation Act in 2022 The bill's goals include fostering innovation and protecting American consumers. Meanwhile, the bill's slow pace can be attributed to the fact that it expands the Commodity Futures Trading Commission's authority to oversee the digital asset sector. Due to the lack of development, Ripple and other cryptocurrency companies are susceptible to enforcement by the State Securities and Exchange Commission. SEC and Ripple are a contrast. Regarding the SEC Ripple litigation, the opposing brief from April 22nd is forthcoming. On Wednesday, investors did not receive any new information to examine. However, April 22nd is the following pivotal date on the updated court briefing schedule. The CCSC's opening brief on remedies has prompted Ripple to file its reply brief. If the challenges of selling XRP to institutional investors after the complaint are resolved, the Securities and Exchange Commissions may be further incentivized. The Securities and Exchange Commission has suggested a $2 billion penalty for breaking securities rules by prohibiting the sale of XRP institutional investors in the U.S. The decision relating the programmatic sales of XRP could be further driven to appeal by the Securities and Exchange Commission segment if Ripple is found favorable in the ruling. Programmatic XRP sales do not meet the criteria of the third prong of the Howey test, as determined by Judge Annalisa Torres in July 2023. In August 2023, the SEC will oppose the ruling by filing a motion for interlocutory appeal, as it has previously indicated. Conversely, the court denied the motion in October 2023, so the SEC would have to wait for the case to finish before filing an appeal. The ever-present prospect of an appeal is a continuing obstacle for XRP. In a recent letter to Treasury Secretary Janet Yellen, XRP attorney John Denton savagely criticized Senator Elizabeth Warren. Warren's letter was the target of Denton's criticism, problems with stable currencies, and the prospect that terrorist groups in rogue states could use them were brought to light in the letter. Meanwhile, Denton made his criticism known to the public on the social media platform X. An XRP supporter named John Deaton has spoken out strongly against Warren. By drawing attention to the fact that Senator Warren had the wrong priorities, John Denton raised the issue. A number of problems have recently emerged in Massachusetts, including but not limited to increasing taxes, income disparity, soaring prices, opioid addiction, deficit spending, illegal immigration, and wealth flight. The financial business is being represented by Elizabeth Warren, according to Denton's writing. She is making every effort to guarantee the continued success of the banking industry. The XRP supporter went on to say that the senator is supposedly unconcerned with pressing domestic problems, like the ones affecting the hospitals. It is sad that she didn't give such serious consideration to events at home, such Steward hospitals, Deaton went on to add, medical facilities. The government affairs lead at technology investment team, Paradigm, Alexander Grief, issued a post in response to the remarks made by the XRP attorney, posting screenshots of Warren's letter to Janet Yellen, the Secretary of the Treasury. Grief made a post on X. Grief claims that the amount of letters opposing stablecoin has recently surged. This is another message directed at Treasury Secretary Janet Yellen, requesting her to support anti-money laundering legislation regarding stablecoins that includes provisions for DeFi system nodes. The XRP attorney has also spoken out strongly in Coinbase's lawsuit against the SEC. In an interview with Fox News writer Eleanor Tourette, Deaton recently revealed that within the next month, he will be submitting an amicus brief representing Coinbase. That's all for now.